26T360. Mr. Schultz appears without counsel. The fancy word for that is pro se. Mr. Holmes and Mr. Schwanevelt are here from the district attorney's office. And I was wondering if you were going to apply for a public defender.
Nope.
Nope.
I'm prepared. I got my documents prepared right in front of me, ma'am.
Well, it might not be that easy. So here's the deal.
Magna Carta, chapter.
Oh, 2 in one day. I'm gonna, go ahead. You can make your record.
Magna Carta is either chapter 16 or 61. I know I'm getting a little bit of a stress headache.
Okay, don't just take a breath.
UCC 3-101.
Okay.
UCC 9-101.
Okay.
Black's Law, 7th edition. Person, second definition. Artificial person, straw man, corporation as defined by law.
Okay.
Executed by Emperor Constantine of the Roman Empire and to date never challenged.
Okay.
Non-juris corpus. I am not a judge. Magistrate. Executor of a dead person's property while I still live and breathe.
Okay.
Yes. Birth certificate is proof of a $1 quintillion private corporate banking account held in trust since I was born, which I was legally supposed to be executor and holder of in due course on December 27th, 1978, 48 and almost 1/2 years ago. That is now escalated to 500 quintillion for the delay, constant harassment, constant physical and verbal assault, and constant fraudulent activity to extort my money. California Business and Practice Section 6067. Every person on his or her admission shall take an oath to support and defend the Constitution of the United States of America and the Constitution of the State of Residence against all enemies, foreign and domestic. A certificate of admission shall thereupon be given to the applicant by the clerk of courts. This shall also be endorsed on said alleged license to practice law and be able to present it upon demand by a defendant now demands district attorney or any lawyer attorney to present such documentation which does not exist, as there is no licensing board or attorneys or lawyers, just a union representative of the acronym British Admiralty Registry, BAR. According to the English language, all capital letters must only be an acronym, a corporation, or shouting. Period. End of report. I demand to see that document. Therefore, the U.S. citizens of that corporation, as established by Abraham Lincoln, residing in one of the states of the Union, as classified as property and franchisees of the United States government as an individual entity. Wheeling Steel Corp. versus Fox, 298 U period S period 19380 L period ED period 114356 S PCTP 773. Quote, the first 8 amendments have uniformly been held not to be protected from state action by privilege and immunities clause of the unredacted, unpassed 14th Amendment, Hogg versus CJL 307 U.S. 496520. Title 18, United States Code Section 242. 49, United States Code 11332, parenthesis 2, 18 U.S.C. Section 1583. The right to travel in a modern day conveyance, aka motor vehicle, is a right, not a state-granted privilege, aka driver's license, as long as I do not operate a business, such as a delivery service or a taxi, out of my personally owned vehicle. An act against the Constitution is automatically null and void. 15 U.S.C. 6802, 15 USC 168 S-2, comma, 5 USC period 1618 period 15 USC 1681 lowercase I 15 USC 1692G 15 USC 1681 lowercase n 16 USC 1681 S-2, of which motels and hostels should not be exempt from 15 USC 1681G, charge offs which should be in my pocket. 15 USC 6802, Federal Debt Collection Practices Act. U.S. Supreme Court, American Insurance Company versus Cantor, 1892.
All right.
I do not consent to be governed any longer as per Declaration of the Independence and Cruden versus Neal. I request a copy of the court's delegation of authority. I request a court master audit to the case for compliance and fairness. I request the court for sealing and expungement of all cases heretofore incurring and hereinafter arising from my and my family members' eventual demise. Furthermore, transaction accounts are unlawfully done. The only entity that can put money into an account, take money out of an account, or transfer money to any account is the physical representation of the corporation itself, not any other person.
Hello everyone, and welcome to today's video. In this episode, we'll look at 4 different courtroom cases involving people who challenge or reject legal authority. Each case brings its own unique situation, with some individuals showing confusion about the law while others display a lack of respect for the court process. The 4th case is especially interesting because there's a new development that follows it. I'll be covering that update in next week's video, so be sure to watch for that. With that said, let's get started and take a closer look at today's cases.
Thank you, Mr. Schultz. Thank you for that record, sir. It's all been recorded, and I am hereby denying your request. I'm going to make my record at this time. Sir, you've been charged under the Colorado Revised Statute 424-1602, leaving the scene of an accident, damage only, all right? Under the 10th Amendment, the states have the authority to enact laws to protect the citizens of that state. I have authority over your case under Article 6 of the Colorado Constitution, Sections 1 and 16, and the Colorado Revised Statute 136106. I have subject matter jurisdiction over this matter under Article 6 of the Colorado Constitution, Section 17, Colorado Revised Statute 181201, and Colorado Revised Statute 136106. I have personal jurisdiction over you as a result that you were issued a summons and complaint under Rule 4.1 of the Colorado Rules of Criminal Procedure. And so this case will be proceeding as follows. You have the right to be represented by an attorney. If you
No,
cannot afford an
I
attorney-
do have a state. I have a
I
statement
listened
ready.
to you.
I do have a
I
statement
listened
ready.
to you. You have the right to be represented by an attorney. If
I
you
don't
cannot
need one.
afford an attorney and you fill out the application for and qualify for the
I
public
don't need,
defender.
I don't need one.
you
I
must
just
be
proved I
appointed
don't need
before
one.
any further proceedings are held.
I
Now,
just proved
here's
I
where
don't-
you and I are going to get into some serious conversation. I understand all your allegations and perhaps your sovereign beliefs. They're a bit disjointed. So what gives me concern is you have every right to believe what you want to believe, but I'm concerned about your competency to understand the proceedings before you today, to understand what's going on, the possible consequences. And should you obtain an attorney, I'd be concerned about your
I do
ability
not
to
need or
assist your
want an attorney.
with your defense. So how these proceedings go are, if you don't want to accept a plea agreement or entertain a plea agreement made by the people, you have the right to plead not guilty and take this matter to trial.
I do have a statement if I'm
not
if I'm allowed to make it.
I'm not finished. If this matter goes to trial and you represent yourself, you would be held at the same standards as an attorney would be held
Mhm.
in terms of knowing the rules of procedure and the rules of evidence.
Mhm.
If you're convicted, you would have the right to appeal. If you're acquitted, no further
Mhm.
action would be necessary.
I have no problem going to a jury trial, but I can't pay for it.
You don't have to pay for it.
Okay. I request a jury trial.
Okay, so are you entering a plea of not guilty today?
Okay. I'll hang on to this.
I don't know what that is. So, sir,
It's
he-
my paperwork.
here's how the jury trial would proceed. The issue before the court in a jury trial would be one issue and one issue only. And it would be whether or not on June 5th of 2026, you were involved in an accident and you left the scene of that accident. It would have nothing to do with what you believe are your rights under any sovereign principles. Your jury trial would be to determine whether or not the people could
The
prove
ultimate-
to the jury
I have the ultimate killer
that
statement.
sooner
on that
about
one, too.
January 5th of 2026.
I have the ultimate killer statement on that one too.
Okay, a killer statement may not get you very far. I mean, granted, this is a class 2 traffic offense, but it does carry the possibility of 10 to 90 days in jail. And so
See the inside of a jail cell again, trust me.
I do trust you, but I'm also very concerned about your ability to
I'm not trying to
understand
take
these
too much of your time,
proceedings.
ma'am. May I go?
At this point, it almost sounds like you're presenting arguments that don't align with how the legal system actually works. Let's clear up a few common misunderstandings. First, when courts refer to the bar, they're talking about the physical barrier that separates the public seating area from the space used by attorneys and parties involved in a case. It has nothing to do with claims about foreign registries or similar theories. Second, the constitutional right to travel generally relates to moving freely between states. It does not eliminate requirements such as driver's licenses, vehicle registration, or traffic laws that apply to public roads. Finally, if someone disagrees with how a government operates, that doesn't automatically remove them from its laws or authority. In the United States, both federal and state governments have recognized powers, and states retain important governing authority under the 10th Amendment. With those points addressed, the court is now ready to respond to these arguments and explain how the law applies to the situation at hand. The judge's explanation is likely to provide a clearer understanding of why these claims have consistently been rejected in court.
I am going to give you,
Am I being held?
I'm going to give you, you're not being held, but but if you walk out the door without me giving you permission to walk out the door, I also have the authority to issue a bench warrant. And so let me, I have to give you what, I am concerned with your ability to understand the nature and course of the proceedings against you, or of participating in your defense, or cooperating with, if you had defense counsel. And
Yeah.
so,
Ma'am, if I may interrupt, I had to self-diagnose myself with ADHD.
right,
I'm a non-lateral thinker.
but my
Okay.
son has that, AUADD, yeah.
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 And like I said, I do not need an attorney or any counseling whatsoever. I'm going to be seeking my own counseling through the Veterans Administration. I am a 100% service-connected vet because of this.
Okay.
And I just need the time to get that set up here in Colorado Springs.
Right. Here's my concern. My concern is that we have this legal proceeding, and I don't believe that if you are determined to be incompetent, we can't go forward on any of these proceedings, and you would get the counseling that you're
I'm
requesting.
standing here before you, presenting my case.
Right. The issues that you raise in presenting your case are, as I said, disjointed. They're irrelevant to the matter at hand. They're born of what I understand you believe to be necessary and required, but they have no basis in law under under the U.S. Constitution, the Colorado Constitution, or the laws of the state.
Can I make a statement on the exact case?
You'll
while I'm
make
standing here?
one more statement, and then I'm going to read you your competency advisement.
I was not fleeing the scene. I was trying to move the scene away from away from traffic to a safer place. That's all I was trying to do. I was trying to not choke up the traffic, which was already backed up by 2 other accidents.
So here's the deal. I don't know if, just indulge me. If the people were you going to make an offer? Just indulge me.
Yes, and it would just be plead guilty to leaving the scene with a $300 fine and then 12 months of unsupervised probation with just a making better choices plan.
Yeah, I don't think you're gonna get.
All right, that's what my colleague came up with that offer. In this case, I'm comfortable with just a 12-month deferred sentence and then a fine.
But I still, I mean, I don't know. Mr. Hoffman, as an officer of the court, I'm gonna have you and Mr. Schultz just sit out in the hallway. I don't want to raise.
I need
competency.
water.
Yeah, you know. let me-
There's a water fountain outside.
Yeah, but okay, Mr. Hoffman's going to assist you. Bring it back.
Just want to kind of talk about this.
Yeah, and the offer, and just if you have competency concerns too, I don't want to comp him just for being sovereign. Hi, everybody.
That's correct. You are free to leave if you choose, but there can be consequences for not following a court's instructions. When a person is required to appear in court and decides not to attend, the judge may issue a warrant for their arrest. Court appearances are legal obligations, not optional requests. Ignoring a scheduled hearing doesn't make the case disappear. In many situations, it can create additional legal problems and make the matter more difficult to resolve later. That's why courts generally expect everyone involved to comply with their orders and attend proceedings as required. Failing to do so can lead to further action by the court and additional penalties.
Good afternoon, sir. Can you hear me?
Yes, fellow Mason. Fellow Freemason, I can hear you.
What is your name?
I'm Inky. I'm on the way to the lodge in Salida.
What is your legal name?
Christopher. I'm a follower of God, leader of men. I am
Christopher.
Inky. I am the light. I'm on my way to the lodge in Salida. I'm a fellow Freemason.
All right, Christopher Roberts. Is that your full legal name?
I'm Inky. I do not wish to contract.
I will call you Inky if you wish, but I want to confirm it's you, Christopher Roberts.
You are a Mason, correct?
I'm a judicial officer, Mr. Roberts.
You are a Mason. You are a part of the Freemasonic order.
All right.
I'm Inky. I am the light. I'm a fellow Mason.
Mr. Roberts appears virtually in custody. Inky, one of the rights you have in your case is to be represented by a lawyer. Would you like a lawyer to represent you at this hearing?
I do not need a lawyer. I did not
All right.
agree to contract. I was doing nothing wrong. I would like this solved today. I literally parked my vehicle. I took a walk over to the gas station to take a dump. I came back.
Okay, Mr.
There was an officer. You work for me. You will listen, please.
No, I'm muting your microphone. I'm trying to mute it. Thank you. And the reason I'm doing that is because you have a right to remain silent. Anything that you say can and will be used against you. I'm going to advise you of the other rights that you have in your case. You have you are presumed innocent. The burden is on the prosecutor to prove any charges against you beyond a reasonable doubt. In this case, you've been charged with a Class 2 misdemeanor, resisting arrest. Any guilty plea you make in this case must be voluntary, meaning that you were not coerced or unduly influenced to plead guilty. A conviction may adversely affect your immigration status. If you are a veteran, you may be entitled to other resources, and you can contact the Veteran Services Office to be connected with the Veterans Court. Mr. Ibsen appears virtually for the people. Argument for bond.
Judge, people don't have a problem with the PR bond in this case. He does have a warrant out for him in another jurisdiction. Don't know what that's going to do to him, but
All right, thank you. The court finds probable cause for the charge of resisting arrest in the affidavit. The court will order a $50 personal recognizance bond. Are the people requesting any other conditions, Mr.
no,
Ibsen?
ma'am. No, ma'am.
All right, thank you. All right, Inky, I have unmuted your microphone. What I have ordered is that you will be not held in this case by any monetary amount. However, you do have a warrant in El Paso County, which is Colorado Springs, which may be holding you. Once that case is resolved, this resisting arrest will not prevent you from being released from custody. Do you have any questions?
No, thank you, Your Honor.
All right. Your next court date will be Tuesday. Mr. Ibsen, what time are the in custodies
I'll be at the
normally
lodge
held?
with Lida.
Judge,
If
it's
you know.
pretty variable. They can be either at 11 o'clock if it's a public defender client, or 1:30 if it's a private client.
All right, we'll do this at 11 o'clock. Mr.
Sovereign, I'm Inky. I am not the name you gave that the Social Security Administration gave me. Okay? I am awake. I'm a free living man. I am not a citizen. Okay? I am a sovereign. I'm a fellow Mason. Do you understand me?
I understand that you are a sovereign.
You have a nice
I
day.
have set your bond at $50 personal recognizance, and your next court date will be
I
Tuesday.
don't have any money, Your Honor. I am destitute.
I'm not requiring any money for you to be released on this case. A personal recognizance means that you can sign out of the jail on this case. However, there is a warrant from El Paso County, and you won't be released until that is resolved.
That's where this part of the hearing came to a close. After taking a short break, the parties returned and reached an agreement to offer him a deferred competency arrangement. While there doesn't appear to be a clear public explanation of exactly what that term means, it likely suggests that any sentencing decision would be postponed until his competency status is officially determined, as on the information presented so far. It seems unlikely that he would be ruled incompetent. The court will ultimately rely on established legal and medical standards when making that decision. Simply holding unusual personal beliefs is not necessarily enough to affect a competency finding on its own. With that matter temporarily settled, the focus shifts to the next individual on the schedule. His hearing takes place while he remains in custody, bringing a new case and a different set of circumstances before the court.
Mr. Trammell, come on up. '21. 26 CR 921 Trammell appearances.
Anthony Santos for the people.
And let the record reflect that we have Mr. Trammell here. We're set for arraignment today. Mr. Trammell, how would you like to move forward?
First of all, Your Honor, is this a court of record? Can I get a stenographic report of this proceeding?
No, we don't do stenographic recording. There's an FTR machine. It is being recorded. If you want a transcript after this hearing, you can request it.
Yeah.
How do you want to move forward? Do you want to enter a plea of not guilty so that we can get this case moving? Or do you want to reach a disposition and enter a plea of guilty? How would you like to move forward?
Can you repeat that, please?
We're set for arraignment today.
Yes.
At arraignment, you can either plead guilty or not guilty
Guilty or not guilty to what?
to the charges.
Which are?
You are charged in this case with possession of a dangerous weapon and large capacity magazine prohibited. And let me make sure that I give you the state statutory cites. Possession of a dangerous weapon pursuant to 1812-102 subsection 3. Large capacity magazine prohibited during crime, 1812-302 subsection 1, subsection 1AC. Now, what is your plea? Guilty or not guilty?
I'm gonna just plead guilty or not guilty. I have a question. I do have a right to know the cause and the nature of this
You can do
particular
that. You're
offense.
not going to do that today in court. You can seek discovery, you can communicate with the district attorney's office, and you can ask for discovery. How are you moving forward today? Guilty or not guilty? That's what we're doing today. It's you're set for arraignment. I told you last time we were here, you wanted to,
I
if you wanted
understand
to apply for an attorney, you
understand
didn't
that.
want one?
However, under the Sixth Amendment, I do have a right to know. It affords and guarantees me the right to know the cause and nature of this particular action.
Sir,
Ma'am.
you're
And
set
it's
for
your duty
arraignment.
to tell me what the cause and nature of the action is.
You're set for
Is
arraignment.
this a criminal or civil offense?
This is a criminal offense,
Okay, so
sir.
under the Constitution, there's two jurisdictions. One is under the common law and the other one is a condition of contract. On the colorable elements of a.
I don't
admiralty
know
jurisdiction.
whether or not you're getting
Which
your.
two of these jurisdictions will you
Let
hear
me
this
tell you what
case
you're
on?
not going to do today, Mr. Trammell. You are not going to interrupt me when I'm speaking. Do you understand me?
I'm not interrupting you.
Okay. Now, you are here for arraignment. And I'm
Totally
going to ask
understand
you.
that, but you're not answering my questions. I can't adequately answer the question
You're
until
here
you
for
answer
two
mine.
criminal charges. Okay?
Okay, so is this common law or are we under the tolerable admiralty jurisdiction?
These are statutory, this is
Okay, but you're not
statutory.
answering my
This is not
question.
common law.
You're not answering my question. And I'm not interrupting you. I'm not being loud. I'm asking you a simple question. It's my right to know. And you're not
Sir?
telling me.
Sir, you are here pursuant to statutes. Okay?
You did not answer my question.
Okay. Sir, common law. Now,
Common law?
do you plead guilty or not guilty,
Okay, so we're
sir?
under the common law. Where is the injured party? Under the
Sir?
common law.
Sir, the people are the injured party in this case. How do you plead guilty or
We'll put
not
the
guilty?
people on the bench then.
You're going to enter a plea of not guilty today.
So
We're
now
going to
you're
set you for
practicing law from
trial.
the bench, aiding the prosecution?
Where's the paperwork? Not
Let the
guilty
record
plea
reflect that
enters
Your Honor
today.
is practicing
Your
law
speedy
from the
trial
bench
runs
and aiding the
on
prosecution.
December 5th, 2026. Motions are due on July 6th, 2026. Your disposition date is scheduled for July 27th at 8:30.
You said July 6th?
July 6th, your motions are due.
And what was the other date?
And July 27th, you're set for disposition. If testimonial motions are filed,
27th?
the 27th of July. If you file testimonial motions, I'll set a motions hearing then. Thank you. Your speedy trial again is actually December 4th. We'll see you on July 27th. Thank you. Bond continues.
For now, it appears that his situation will remain unchanged until the court reaches a final decision on the matter. Any claims or personal labels he chooses to use will have little impact on the legal process, which will continue according to the court's established procedures. Next, we move on to another case that may sound familiar to regular viewers. This is a follow-up to a sovereign citizen case that was featured previously. The individual involved is Alan Trammell, and this latest hearing provides an update on how his case is progressing. As with many ongoing court matters, new developments have emerged since the last appearance. Let's take a closer look at what happened and see where things currently stand.
Court's going to call People v. Jeffrey Zunick, 25T1074. Jeffrey Zunick. We have one person online, 970 ending in 00. I'm going to take you off mute. Will you please let us know who you are?
Hello,
Yes, who is this?
can you hear me?
I
This is
can hear
Jeffrey
you.
Zunich.
Okay, Mr. Zunick,
Yes, sir.
we just called your case, 25T1074. What's going on in Mr. Zunick's case?
Your Honor, it appears
I'm,
last,
Oh, stand by.
Go
DA's
ahead.
office is going to talk real quick. I'll take you off mute when they're done.
it appears last court date, we got to set over because he was trying to get an attorney. I haven't seen anyone entered on his matter. We do have an offer if he would like to speak to us.
Mr. Zunick, can you hear me now?
Yes, I can.
Hey, how is your,
I-
how is getting an attorney going?
Still haven't retained one. I've talked to 3. That's where I stand.
Okay. And Ms. Brawl, we need to clarify count 1 in this case?
14414093.
3?
Yes, Your Honor.
Do you know if that says driver or owner? I think it's driver. No proof. Gotcha. NPOI. Disregard. Figured it out. Okay, Mr. Zunick, I'm going to give you court date on March 30th at 10 a.m.
Okay.
And please try to get, if you are going to retain counsel, please get them to enter in your case. If that does happen, you may
Okay.
we may change the court date, but as of right now, that'll be the court date you have.
March 30th at 10 a.m.
Yep, March 30th at 10 a.m., sir.
Thank you.
Do you have any questions for me?
I don't.
Okay, thank you, sir. You may disconnect.
You bet.
Jeffrey Zunick? Is there anybody online, the last name Zunick? Jeffrey Zunick.
Yes, sir. Yes, sir. Can you hear me?
I can hear you.
Okay. Sorry about that.
Have
I couldn't
you
reach my butt.
had the opportunity to talk with the district attorney's office?
I have not, but I have spoken with counsel, and we'll be filing what we need to file in the next day or two.
Okay, so you have retained an attorney?
I haven't retained an attorney. I've just sought counsel with a consultant.
Okay. So you don't have an attorney that's going to enter in your case?
No, I'll be
Okay.
pro se and filing what I need to. Like I say here, maybe have it finished up tonight, and I can bring it to the courts, to the clerk in the morning.
Okay. Let me just look up your case real quick. Last note I have, it said you were trying to get an attorney.
Yes.
So I guess the big question I have, you're going to proceed pro se without a private attorney
Yes, sir.
or any attorney at all? Okay. What do you want to do going forward? Do you want more time to negotiate with the district attorney's office?
I would like more time. Just I'll file the paperwork, like I say, one day this week, and we can go from there.
Okay. How long will it take? What are you filing exactly?
Oh, I'm not. I got a couple of motions and a notice.
Okay. I'm going to bring you back next week
Okay.
on April 6th at 10 a.m.
April 6th at 10 a.m. Thank you, sir.
Yep. If there's no movement in your case, we will set it for trial that day.
Okay. Sounds good.
Okay. Thank you, sir. Your next court date is April 6th at 10 a.m.
10 a.m. Thank you, sir. Appreciate it.
All right. Thank you.
Bye-bye. You bet. Bye.
This is definitely a case worth keeping an eye on, especially because of the way he has interacted with the court. Throughout the proceedings, his behavior has often been seen as confrontational and lacking the level of respect typically expected in a courtroom setting. Now, we move to the final individual featured in today's review, Jeffrey Zunick, a sovereign citizen whose case has been followed over the past several months. There have been a number of developments in his legal proceedings, making this one of the more active cases to watch. Today, there are 5 separate hearings to go through. We'll begin with the first 2 hearings, then cover the next 2, and finish with the final appearance. By the end of that last hearing, events take a significant turn, resulting in the court issuing a bench warrant.
All right, next, Jeffrey Zunick.
Yes, Your Honor. Hello?
Hi, can you hear me?
Yes, I can hear you.
All right, Mr. Zunick, your case is set for a plea hearing. Have you had an opportunity to speak with the district attorney's office?
I have not, but I had a notice filed this morning, and I would give you time to look it over. I don't know that you've received it yet.
I have no idea what you're talking about for notice.
It was just filed this morning. I had a server file with the court, with the clerk.
Okay, are you wanting to get counsel, speak with the district attorney's office, or enter a not guilty plea and set this for trial?
I would ask that the court look over the motion that I filed, and we can go from there, hopefully.
Well, I don't have the notice or the motion in front of me. If it's a
Could I
motion to
ask for a
dismiss,
continuance?
this case is 139 days old, so I'll give you a 1-week continuance. But that's it. If we don't have a resolution by next week, then
Okay.
I'm going to set it for trial.
Okay, understood.
All right, so your case will be continued till 10 a.m. on May 18th.
Okay.
And Your Honor, if he can be ordered to be in person.
And Mr. Zunick, is there any reason that you can't appear in person?
Just my work.
Okay, we're going to be here in person next time, okay?
Okay.
All right, sir, I'll see you back here on the 18th. And again, if there's no movement on your case, I'm going to enter a not guilty plea for you and set it for trial.
Okay.
Okay, see you then, sir.
Thank you.
Okay, we'll go ahead and continue with the docket. Jeffrey Zunick, 25T 1074. Jeffrey Zunick. Okay, I'll make a finding that Mr. Zunick fails to appear. This case is not eligible for the 40-hour bond hearing requirement. Based on the
I am
charges.
here by special appearance. I am here
Okay.
by special appearance.
Okay, thank you, Mr. Zunick.
On the record, for the record, and let the record show.
This is case number 25T 1074. And this is Ms. Baral's case. Ms. Baral, any updates for the court?
Your Honor, there was a motion filed. Judge has denied that motion. I believe he was to be in person as ordered by court at last court date. He's not here. We're asking for a bench warrant to be issued.
Okay.
I object. Under what grounds?
I do not see. Let's see, hold on.
I have filed several affidavits of truth. I have not had a response from any of them.
Here's what I'm going to do. Mr. Zunick, I'm going to order you to be here in person, but I am not going to issue a bench warrant for your non-appearance today. I'm going to order that you are here in person, and I'm going to set it over for next Monday at 10 a.m. Or sorry, that is a holiday. We're going to set it over for June 8th at 10 a.m. Okay, sir? Thank you very much. You're free to hang up. That's June 8th at 10 a.m. You're ordered to be here in person, Mr. Zunick. Thank you. That'll be for a plea hearing.
That wraps up his first 2 hearings. One of the more interesting points was his statement that he had spoken with 3 different attorneys, but none of them ended up taking his case. That detail alone raises some questions about how he plans to move forward with his legal strategy. He also mentioned working with a consultant who has been assisting him in preparing and filing various motions and notices. It will be interesting to see how those filings are received by the court and whether they have any meaningful impact on the case, as the proceedings continue. the focus will likely shift to the arguments and documents being submitted on his behalf. With several hearings still ahead, there is plenty more to review. Let's move on to the next 2 hearings and see what developments come next.
Jeffrey Zunick?
Appearing special appearance by the phone. I appear
Okay,
under special appearance as opposed to general appearance by phone.
If you're going to start the sovereign citizen stuff, we're just going to continue your case.
Well, Your Honor,
I've never mentioned any sovereign citizen.
Well, appearing general counsel is not what you do when you appear in person or appear. Ms. Brawl, do you have a motion for the court?
Your Honor, just for the court's record, Mr. Zunick was on WebEx on the 30th of March. Court ordered him to be in person. He appeared via WebEx again on the 11th of this month. Or wait a sec. On the 11th of last month, he was on WebEx. The court ordered him to be in person. On the 18th of last month, Judge Thomason was covering. The people made a motion for a warrant because he wasn't in person. Since Judge Thomason was covering, she didn't ask for a warrant, and she also ordered him to be in person. He's still not in person today. We're asking that the court issue a bench warrant.
I object and deny.
Objection noted. I'm issuing a bench warrant in the amount of.
On what ground?
I'm issuing a bench warrant in the amount of $500 cash only.
On what
And
grounds?
he is eligible for 48-hour advisement. Mr. Zunick, we're trying to have you in person. You've refused to come in person, even though the court, as the people have
refuse to come in
outlined,
person under fear of being kidnapped and held against my will.
If you want to keep talking over me, we can go for contempt too. All right, Mr. Zunick,
Could the court
do you want to keep
show
talking,
cause?
Sir, you will stop talking over the top of me, and I'm going to issue my order, and then I'll answer your questions. Do you understand?
No, I don't understand.
I'm issuing a warrant for your arrest because you're not here in person as you've been ordered to do so previously. If you want to have a show of cause hearing, I can find you in contempt and we'll have a short cause hearing on contempt. All right. Defendant is eligible for 48-hour advisement. That matter concludes your matter. Mr. Zunick, you can disconnect from the phone.
I'd like to address the court.
I'm done with your case.
Court.
You can turn yourself in on the warrant.
You're
And you can come
violating
here in person. I'm going to expel him from the.
You are violating my right to due process.
There wasn't much of significance to report from those 2 hearings. The main development was that the judge overseeing the case specifically instructed him to appear in person for future proceedings. However, he chose not to comply with that order. So, did he eventually follow the court's direction and attend the final hearing in person? The answer is no. His absence became one of the key issues in the case and played an important role in what happened next. There is a specific reason behind his decision not to appear, and that detail will be discussed later. For now, let's turn our attention to his most recent hearing and take a closer look at how the proceedings unfolded.